Untitled, my relatives, my friends, the people that are here today, I just want to say to the pipe carriers and the people that lifted the pipe this morning and the way we start, and our drum groups and our elders, thank you so much for giving me an opportunity to speak here today on behalf of Affinity Credit Union. On behalf of Affinity Credit Union and in the spirit of reconciliation, I'd like to acknowledge that we are on Treaty 6 territory, homeland of the Métis, and traditional territory of the Dakota people. We pay our respect to First Nations, Métis ancestry, and reaffirm our relationship with one another and Mother Earth. Our vision at Affinity is to build a better world for everyone every day. This is directly aligned with what we're here today to talk and hear and listen about reconciliation. The goal of reconciliation is to bring us all together, Indigenous and non-Indigenous, to make a world that's a better place for everyone. In order to move forward together, we need to acknowledge our past. We've taken many steps in Affinity, including lunch and learns, many activities within the organization as it relates to truth and reconciliation. We were one of the first financial institutions to adopt the call to action 92, which is very important to the organization. There are many relationships that we've developed over the years with various organizations as it relates to truth and reconciliation. In keeping with these goals of education and reconciliation, it brings me great pleasure to introduce our speaker, member of Gordon First Nations in member of Gordon's First Nation here in Saskatchewan, and a first-generation Chinese Canadian. I wanted to reflect on this introduction, and I knew I was coming. I knew I was going to introduce the senator, and not really knowing who I was introducing. So of course, with technology, I was able to go on to the internet, put in her name, and the material that came up. The opportunity to briefly meet this morning was very important. And I just want to say, after reading what I read and the things that this woman has done, not only as a First Nations woman, but as a Chinese Canadian as well, the stories, the accolades that she has received over the years that she's been promoting and doing the things that needed to be done within the Senate is very important. Her life story is important. An individual with a First Nations ancestry and Chinese ancestry going back and looking 100 years ago. I could not imagine what this lady has gone through, given that in those early years growing up in an environment where Indians, Chinese, many other cultural things that were not accepted in Canadian society. She overcame those obstacles. She overcame racism. She overcame sexism in the workplace. And her story led to a play that was called The Cafe Daughter. And it was a life story. Could you imagine being told not to let people know that you were Cree? And the effect that that would have on her. And so those are things that we're here today to think about. Wîcihitowin, helping. That's important. We're here to learn. We're here to take away. We're here to make our future better as Canada, as Canadians, and as treaty people. Every one of us sitting in this room are treaty people, and we must recognize that. But we must also work together to make the change that needs to be done to ensure the legacy is not forgotten of residential schools. The things that are in that commission report, the calls to action, are very important. So do our part, do your part. Take away what you learned today and share that. Share it with your family, share it with your friends, share it with the organization that you're here to represent. That's the change we need, is at the high level of organizations, institutions, corporate Canada. That's where we can define the change in Canada, in our society, to have a more acceptable to our Indigenous peoples here in this country. So without further ado, I'd like to ask Senator Dr. Lillian Dick to come up and do her presentation. Thank you so much. To my Uncle Eugene, I kept it under 5. Where is he?
Good morning, everyone. Is this good? Thank you for that introduction, Paul. You know, I've done a lot of speeches across the country on the topic of missing and murdered Indigenous women and girls. This is talk number 110. But this is a very special, special place, and I've cried here twice. And you know, I don't cry very often, but I'm allowed to cry here because it's a safe place. There are very few places where people like myself are safe and where I wrote myself a little note. It's a safe place to be me. That's what I've been searching for, and I know many, many thousands, millions of us, probably every single Canadian is searching for a place where it's safe to be who you are. So I've probably made my talk too long this morning. Where's the little clicker? Could we bring up the presentation, please? I'm going to talk to you about restoring the rights of Indigenous women to safety and to their identity. And it flows very much upon what we heard just earlier with the other panel. As I said, I'm really happy to be here today. I probably have got way too many slides, and I will try to do them as quickly and as concisely and clearly as possible. You'll have to forgive me. I am used to being a professor teacher, and so it's very technical. I love to teach. I love to inform. I do have a personal website for those of you who want to look at the speeches that I've done. I will post this probably next week if you want to look at the written copy. So what I'm going to do today is I'm going to talk to you first of all about violence against Aboriginal women and girls and potential legislative remedies. I'll be talking to you very briefly about Bill S-215 and Bill C-75. I am, after all, a senator, and my job is to review legislation, and I'm very humbled to say that I've been able to actually initiate legislation, and I hope that you agree with me that they're important and good changes. The second topic that I'm going to talk to you about is discrimination against Indian women in the Indian Act with respect to our identity, with respect to our citizenship, with respect to status, and the potential legislative remedies that have occurred over the years, starting in 1985 with Bill C-31 and culminating just this last spring with Bill S-3. It's a big, big job here. So first of all, with respect to restoring the rights of Indigenous women to safety by providing equal protection and benefit of the law, we have known for many, many years that Aboriginal girls and women are more likely than other women to be made missing and murdered, sexually assaulted, and we make exceptions for offenders in our laws, but we ignore the fact that huge numbers of women, especially Aboriginal women, are targeted for sexual violence. So we've heard this before. Aboriginal women are at much greater risk for violence. Aboriginal women are 3 to 4 times more likely than other women to be sexually assaulted or murdered. And there's a variety of sources for that, for those particular statistics. Aboriginal women are 7 times more likely to be targeted by serial killers. And really, it boils down to this: simply being Aboriginal is a risk factor for violence for females, but not for males. And that comes from Stats Canada in 2016. To me, that was a shocking, shocking statement. And women, Aboriginal women, we know that. But now it's been verified by Statistics Canada. And I know Stats Canada is here. I spoke to the lady at the table yesterday. Thank you, Stats Canada, for providing that information. To respond to these horrible statistics, I initiated Bill S-215 in the Senate in December 2015. It was passed by the Senate in December 2016. A year later, this is a picture at the committee meeting with Vice Chief Heather Bair and the president of the Native Women's Association of Canada, who were witnesses during the study of that bill. It went over to the House of Commons. I'll get to that in a moment, sorry. I skipped ahead here. So what is Bill S-215? The purpose of the bill was to add female Aboriginal identity as an aggravating factor in sentencing for violent offenses, because we know Aboriginal women are more likely to be victims of violent offenses. The rationale for it was, 1, to fulfill human rights for Aboriginal females, and 2, to provide similar legislative protection that has been given to public transit operators, service animals, police dogs, and so on. Now, yesterday, one of the youth panel talked about feeling fearful when she got into a taxi and the taxi drivers. Well, we have a bill to protect taxi drivers, but we had no bill to protect Aboriginal women. To me, that was just like, duh. We have a bill to protect service dogs, police dogs, but we had no bill to protect Aboriginal women. Where are our values? So that was, when those bills came forward, that gave me the idea, and I thought, for goodness sakes, if we can do that for a police dog, why cannot we do it for an Aboriginal woman or girl? So, thank you. So the main criticisms of the bill have been that it would counteract the Glado provision, fears that it would increase sentencing for Aboriginal men. And the Glado provisions are those provisions that give special protection for male offenders. So people are worried about that. That's been in place since about 1996. And our justice system is so used to that they cannot think outside the box, and they can only think we have to protect the offenders. It was very difficult to get them to understand the victims are also worthy of special consideration. And thank goodness for the National Inquiry and Commissioners Buller and Kayak and Aopson and the others for changing the way Canadians see our justice system. So that was one of the main consideration. The other main consideration was that it did not provide protection for violence for all women. I had targeted just Aboriginal women. but I had fully intended to amend it, and I had the amendment ready in my hand to say, protect all women, but especially, or in particular, Aboriginal women, but I never got the chance to put that forward for my bill. Unfortunately, my bill was defeated in the House of Commons on April 10th, 2019. That was a very dark day. I couldn't believe how few people voted for it, even within the Liberal Party. That was really very disappointing for me. The NDP and the Bloc Québécois supported it, and I must say here, I very much appreciate Georgina Jolibois and Sherry Benson, our local Saskatchewan NDP MPs, who lobbied very hard to get it passed. And as I said, very few Liberals supported it. I just could not convince them to come on side. And it boiled down to really basically the Justice Minister saying that we had to protect the male offenders. So it was a choice that was made. Despite widespread public support for the bill, including Wîcihitowin, and Darlene just spoke about that group, the Business and Professional Women, the Public Service Alliance of Canada, the Federation of Sovereign Indigenous Nations, other regional First Nation organizations, the Native Women's Association of Canada, and the Assembly of First Nations. We even had resolutions from FSIN. We had a resolution from the Assembly of First Nations to support the bill, but we could not convince, and the commissioners talked about that this morning, we had to have the political will. And as an individual senator, especially since I was not really politically active, it's hard to get that political will to change. So the National Inquiry MMIWG report supported passage of my bill S215, and I was just delighted to hear that. Their final report was released on June the 3rd, 2019, after my bill had already been defeated. However, as I mentioned before, the bill was defeated mainly because most members of Parliament clearly did not believe that a specific category protection should be given to Aboriginal females. And as I said before, I had the amendment in my hand ready to change it to all women, but I never got the chance to appear in the House of Commons as a witness. And it was also defeated because they felt it conflicted with the Glado provisions, which is Section 718(2)(e) of the Criminal Code. It did. It definitely did, but it did for good reasons. So what would my bill have done if it had passed? It would have named Aboriginal female persons specifically as an aggravating circumstance in sentencing their offender in cases of assault, including sexual assault or murder. That is, the judge would have been required to take into account the fact that Aboriginal women and girls are much more likely to be victims of violence and consider their identity as Aboriginal females as an aggravating factor in sentencing the offender. So this is the rights rationale for amending the criminal code. This is the reason why it makes sense in law. One, it was to provide equal protection and benefit of the law for Aboriginal women and girls compared to other women, guaranteed by Section 15 of the Charter of Rights and Freedoms. Two, it was to provide the equal right to the life, liberty, and security guaranteed by Section 7 of the Charter of Rights and Freedoms. Three, it was to protect Aboriginal women and girls from violence as guaranteed by Article 22.2 of the UN Declaration on the Rights of Indigenous Peoples. And fourth, as I mentioned before, it was to provide a specific counterbalance for Aboriginal female victims of violence to the Glado provision for Aboriginal offenders. Now, this is what the Glado provision says. It says all available sanctions other than imprisonment that are reasonable and consistent with the harm done to victims and to the community should be considered for all offenders with particular attention to the circumstances of Aboriginal offenders. In other words, it's a mitigating factor in sentencing. And the reason it was put forth is because we know our prisons are full of Aboriginal offenders, especially here on the prairies. 90% of the prisoners in Prince Albert are Aboriginal. So this was put into the criminal code to divert the offenders from the prisons and try to get them into alternative restorative justice programs. So there is a good purpose for that particular section. Now, those very same Glado factors that have disproportionately affected Aboriginal women and girls have created the racist stereotype of Aboriginal women and girls as easy targets for sexual violence, and thus they have become more likely to become victims of violent crimes compared to other women. It's really racism again. Thus, a provision such as designated Aboriginal female identity, specifically as an aggravating factor, is warranted and necessary to overcome inherent biases against them in society and to balance Section 718.2E of the Criminal Code. Now, earlier this morning, in the first panel, we talked about justice being blind, being not blind. Well, I say justice is blind. Justice is blind to the systemic racism, to the systemic sexism with all the people that work within the system. So we need something to counteract that systemic racism that the participants, not all of them, but too many of them, are blind to their own systemic prejudices and biases. Now, I have done some research with research at the University of Saskatchewan, and we found a few court cases in which judges have begun to discuss and consider the relevance of the female Aboriginal identity of victims of violence in sentencing. And I will cite one example which supports the need for and rationale for amending the criminal code, such as would have happened with my bill S-215. In a case called R versus PJB in 2015 in British Columbia, the judge said it was probable, in her experience, that both the victim and the offender involved in these instances would have been impacted by the Glado factors. And the Glado factors are things like, you know, the intergenerational trauma from having attended an Indian residential school, the poverty, the racism, the alcoholism, the substance abuse. She noted that due to the prevalence of violence against Aboriginal women, sentences for such offenses should attract particularly deterrent sentences. That means it should be like an aggravating factor. In other words, she's saying that Section 718.2E of the Criminal Code is one-sided and favors the Aboriginal offender over the Aboriginal female victim of violence. And this is what I would consider to be an unfair, unintended consequence of Section 718.2E. Now, I was really happy. I've got a really brilliant assistant in Ottawa who's a lawyer. And she looked up, researched, Googled, and found these two papers that support the need for this type of aggravating factor. There were two recent studies that showed that the application of Section 718.2E to offenders puts women at risk for sexual violence. In 2012, a paper by Balfour said, Aboriginal women are not as protected or have access to protective provisions in the criminal code that their male Aboriginal offenders do via Glado. So she's saying the men are protected, but the women aren't. It's missing. And in 2018, Grant said, non-custodial sentences, that means don't put them in jail, do not provide adequate protection for women who are victims of male violence. And she was here talking specifically about intimate partner violence. This is a really important point because we're talking about women's safety, and many scholars have talked about this. We don't want to put the men in jail, but if we don't put them in jail, we don't remove them somehow, in cases of intimate partner violence, the woman's safety is at risk. So we have to balance her safety against the consequences for the action that the man has done. Section 718 has been found to counteract Section 718-2A2, the criminal code. I know this sounds all these crazy numbers. What this is saying is that Section 718-2A2 is a provision that talks about what could be called domestic abuse or intimate partner abuse. And so Section 718, which is protecting the Aboriginal offenders, has been found to override the provisions on domestic violence. Even though the provisions on domestic violence are like an aggravating factor, the provision to protect the offender has overweighed the provision to protect the survivors of domestic violence. So they have demonstrated that this is what is happening. So I noticed, even though my bill had died, this was Plan B, I noticed that there was a clause in Bill C-75 that could be amended to provide provisions similar to my bill, if I could find witnesses to testify accordingly. So I asked to become a member of the Legal and Constitutional Affairs Committee and suggested witnesses to testify, and I was very happy that Chief Commissioner Buller and Commissioner Kayak Robinson appeared, and we had witnesses from the Indigenous Bar Association and so on, who took this on and provided powerful testimony. So in Bill C-75, what were the clauses that I looked at? It was the clause on intimate partner violence. Now, intimate partner violence, we know, is directed mainly against women by men, and it is the leading cause of violence against women here and all around the world. It is even worse in some Aboriginal communities, and as we know, Aboriginal women are more likely to be victims. It's like the Me Too movement, where women across Canada have said that they have been subject of sexual violence and we don't talk about it. But in the Aboriginal community, I think it's Me Too, but worse. So compared to other women, Aboriginal women are 3 times more likely to be victims of intimate partner violence and 8 times more likely to be killed by an intimate partner. So it is a big source of abuse and murder in our communities. It isn't the only source. We also have stranger violence, but the stranger violence is a smaller percentage. So with respect to Bill 75, the clause that was relevant to violence against Aboriginal women, before Bill C-75 was enacted, it read, evidence that the offender in committing the offense abused the offender's spouse or common law partner. And that essentially means that it's an aggravating factor in sentencing when an offender abuses his spouse or common law partner. Under Bill C-75, this clause was replaced by evidence that the offender, in committing the offense, abused the offender's intimate partner. And what they did here is they changed the definition of Indigenous partner. They expanded it to include a dating partner. So they broadened the scope of who it would apply to. So I thought, well, here's an opportunity to amend the bill to actually insert in there something about Aboriginal women. So I asked the clerk of the Senate to draft amendments which would have the same effects as my bill, that is, make women, in particular Aboriginal women, an aggravating factor to ensure the offense is taken seriously by the judge and jury and an appropriate sentence is levied. Because unfortunately, other research that I conducted with the University of Saskatchewan, we discovered when the Aboriginal women, victims of homicide, when the victim is Aboriginal, an Aboriginal female, a lighter sentence is given. So we have to make sure that that doesn't continue to happen in the past. So what these amendments would have done, they would have made intimate partner violence against women, in particular Indigenous women, an aggravating circumstance for intimate partner violence. I also proposed adding family member abuse to Bill C-75, and because of witness testimony and because research data, my own and that of the RCMP, showed that family member violence was a major source of violence against Aboriginal women. It isn't just intimate partners. So the testimony at the committee hearings supported my amendments to add family member abuse and basically to add enhanced sentencing provisions for women, especially for Aboriginal women, because of their increased risk of sexual violence. Now, we had enhanced sentencing for Aboriginal victims does not negate the Glado provision. That was the criticisms put out by people that it would negate the Glado provisions, but people like Chief Commissioner Buller said that amendment to 718.2 to include indigeneity as an aggravating factor doesn't necessarily outweigh or negate the Glado principles as they apply to the accused. Others made similar comments, including 2 senators who were judges, that being my friend in our hero, Senator Marie Sinclair, and another judge, Senator Dalphon. Now, there's also, in some circles, the idea that somehow Indigenous women are not unique, but I did get from a witness from the Indigenous Bar Association to say that Indigenous women are unique compared to other women, thus they need to be given special consideration. The statistics overwhelmingly show this. We always have to prove this. The evidence has been there for decades. So Catherine Hensel said that in terms of our history of colonization, the tragic legacy of residential schools, the discrimination we face, that's as Aboriginal women, the discrimination we experience in the criminal justice system is distinct. Now, my amendments to Bill C-75 are based on the aforementioned testimony and the proven increased vulnerability of Aboriginal women. My 3 amendments were passed at the Senate and received royal assent on June the 21st and came into force on September 24th. Ten minutes I have. Okay, a brief plain language description. The first amendment was the simplest. That was adding a member of the victim's or the offender's family to broaden the scope of what is intimate partner violence. So it captures other offenders, such as uncles or cousins. The other 3 amendments instruct the judge to hand down stronger sentences for victims who are women, Aboriginal women, and other vulnerable persons, including equivalent to making them aggravating factors. So then it would also include gender diverse. The government actually expanded my amendment. I had to keep it very narrow, otherwise it would be ruled out of order, but the government can do whatever they like. So they were able to expand it beyond just intimate partner violence, and they changed one amendment to abuse, which means any kind of abuse enacted on vulnerable persons. Now, these are historic changes to the criminal code. They acknowledge and counteract the systemic prejudice against vulnerable persons, women and Aboriginal women in particular, in the application of the criminal code in cases of abuse, such as domestic abuse, sexual assault, and murder. I believe it's the only time in history that we've actually added in specifically women and Aboriginal women, so that we know we're not getting a fair deal. And so this is setting that record straight. Chief Commissioner Buller was a witness. We had the report that the National Inquiry came out, recommended changes to the criminal code. This is a picture of the report. I attended the launch, and I just found that the book and the ceremony that you did, it was so powerful. I just had to put my hand on it just to feel the power of the words within those documents. The report recommended enactment of my bill. And these amendments honor our missing and murdered Indigenous women and girls, all women and vulnerable persons, by protecting them specifically in our laws. It surprises me that so very few reporters even noticed. They don't seem to care. They noticed Elizabeth May had, photoshopped a straw in her cup, but they didn't notice something as important as this. But that's the way politics goes. Okay, very quickly in 5 minutes, restoring the rights of Indigenous women to their identity. I called it citizenship originally, but it's really about our identity. As status Indians according to the Indian Act. Now, that's not the best definition of identity, but let's face it, status Indians have rights within, even though we hate the Indian Act, we have certain rights that are embedded in the Indian Act. And the information in the following slides is based on inheritance of status in the matriarchal line, based on women marrying non-Indigenous women in successive generations. So, loss of status by Indian women and her children by marriage to a non-Indian. That was my case. My mother married a Chinese man. It began in 1869, 150 years ago, under an act called an Act for the Gradual Enfranchisement of Indians. And in 1876, in the Indian Act, it allowed white women to gain status by marrying Indian men. So the women were disadvantaged, the Indian women were disadvantaged, but the white women were advantaged, or the men were given an extra benefit by marrying a non-Indian woman. She became an Indian. Even though there were some of us that were half that, we weren't. So that's how perverse that system is. So the main intentions of that was to reduce the number of registered Indians and thereby reduce federal fiscal responsibility, to eliminate matrilineal lineage and the power of matriarchs in traditional Indian societies, and replace it with and establish patriarchal lineage and power structures of 19th century England. They wanted us to be like them. They were trying to destroy the system that was already here. So in 1951, the official Indian Act Registry was initiated. And as I said, the Indian Act rules on marriage were more restrictive for women. In essence, we had a single mother rule. If your mother married a non-Indian, she lost her status and you didn't have any. Until, and I'll skip right over here till 1985, and we had our champion there, who is now a senator, Sandra Lovelace Nicholas, she took her case to the United Nations, who ruled that Canada was discriminating against Indigenous women, and then the government was forced to do something about it. And I'll skip over here. Under that provision, my mother's status was restored as a 61C Indian, and I became a 6'2" Indian. These categories of status were considered inferior to the 61A Indians, and often we weren't seen as real Indians. But the thing is, you know what? In the last 10 or 15 years, us off reserve and intermarried are the majority. So who are the real Indians? And the reason I wasn't an Indian was not my fault. It was because of this government policy. My mother could not live on the reserve anymore. She had to leave. So we lost our family connections. I don't know my cousins. I've met them, but didn't go back till I was 36. When I got my doctorate, I thought, okay, I've been ashamed of being who I am all these years. I inherited that from my mother. She told us never to go back. Well, it's hard to make up those number of years. I'm 74 now. I have to retire in August 2020. I'll be glad, thank you. Tired of the travel. So Bill C-31 didn't fix it. There was Bill C-3, it didn't fix it. So then we got to Bill S-3, which came to us about 2 years ago. To make a long story short, the government came to us with this bill and they kept saying, we have removed all sex-based discrimination in the Indian Act. We're looking at them thinking, no, we don't think you have. We look at this and we can see there are problems. So our committee, the Aboriginal Peoples Committee, and I was the chair, said, you just take this bill back. we're not going to look at it because we're not going to look at it, we're not going to study it until you bring it back to us it's in better shape. It's like giving them a failed grade and a chance to get a pass. So they came back to us with a few amendments that weren't good enough. So then we inserted in the proper clauses to make it work, and they rejected them. But we kept holding our cards saying, we're not going to pass this unless you fix it. And then finally, at the very end, they came up with their own, what we call 6-1A all the way remedy, and the Senate said, okay, we'll accept it. They wouldn't implement all the provisions at first, but we compromised. We said, okay, we'll give you a year and a half. And the whole thing was implemented on August 15th this summer. And what it means is that if you have an ancestor back to 1869, and basically you're going to have to prove it somehow, it's going to be difficult. Any descendant of a woman who lost her status because her great-great-great-great-grandmother married a non-Indian, you can have 6-1 status. If you marry out, your children will be 6-2, but if you continue with the marrying out after 2 generations, you lose status. But it has righted a historic wrong. So thank you very much.